All right, we're going to get ready to start here in a minute. Come on in. Got a little bit more pizza up here. Well, welcome. Welcome to today's Federalist Society debate entitled Rule of Law, Does Our Constitution Face Death by Due Process? I hope most of you enjoy some pizza. I think the DBA is under a funding freeze right now, so some of this pizza might end up being on me. My name is Patrick Hansen, Vice President of the Student Chapter of the Federalist Society. The Federalist Society for Law and Public Policy Studies is a group of conservatives, libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. The Society seeks both to promote an awareness of these principles and to further the application through their activities. This debate is one of several events the Federalist Society has had this semester at Duke. Our topic today relates to an opinion journal article written by Professor Lino Graglia last May. The article was entitled Rule of Law, Our Constitution Faces Death by Due Process. It was related to contributions made to a book edited by Robert Bork entitled A Country I Do Not Recognize, The Legal Assault on American Values. I think it's available now, actually. And now for brief introductions. Here on your right, North Carolina law professor Arnold Loi was a senior editor for the Boston University Law Review and received the law school's Academic Achievement Award for obtaining the top academic average in his graduating class. He became a member of the Connecticut Bar in 1966. He was an assistant professor at the University of Connecticut Law School from 64 to 68. He was an associate professor at UNC at the Carolina Law from 68 to 73 and has been a full professor there since 1973. He became a Graham Keenan professor in 1991, and he publishes and teaches in criminal law, criminal procedure, and constitutional law. And on your left, Texas law professor Lino Graglia received his LLB from Columbia in 1954, where he was also on the Law Review. He worked in the United States Department of Justice during the Eisenhower administration. He has since taught at the University of Texas Law School, where he is the A. Dalton Cross Professor of Law. He has written widely in constitutional law, especially on judicial review, constitutional interpretation, race discrimination, and affirmative action, and also teaches and writes in the area of antitrust. We will pretty much proceed from here. We'll have opening remarks by Professor Graglia, followed by some remarks by Professor Loewy, and we'll save the last few minutes for a few questions. Professor Graglia.
Thank you. His Italian is weak. It's really Graglia. Also, if you write op-ed pieces, Times, Wall Street Journal, and so on, the one thing you don't get to write, you may not realize, is the title. The paper makes up the title, and the title can be very unusual. So they come up with death by due process. I don't know where they got that. That's not mine. But I will give you a complete course in 20 minutes, I hope, in full understanding of constitutional law, the central question of which is, the only question that ties together the myriad subjects dealt with under that heading, is the proper role of the Supreme Court in our system of government. The basic principles of the system of government created by the Constitution are representative democracy or republicanism, that is, government by the people through elected representatives. Federalism, that is, decentralized government with most policy decisions made at the state level, and separation of powers with elected legislators making and unelected judges merely applying the law. For more than 5 decades now, however, virtually every basic change in domestic social policy has come not from elected legislators, state or federal, but from the Supreme Court, a committee of 9 lawyers, unelected, holding office for life, making decisions for the nation as a whole from Washington, D.C. Totally undemocratic, totally centralized, with the judiciary performing the legislative function. This is the antithesis of the constitutional system. In the place of the constitutional system, we have now arrived at a system similar to Iran's. In Iran, as here, the people vote, legislators are elected and pass laws. The laws, however, do not go into operation if the Ayatollah disapproves. Here, the Supreme Court performs that function. It is the court that determines public policy on the issues that determine the nature of a society, the quality of a civilization. For example, issues literally of life and death, as on abortion, capital punishment, assisted suicide. Issues of sexual morality, as decisions on pornography, contraception, homosexuality. Issues of public order, as decisions on vagrancy control, street demonstrations, and the criminal law. The court has disallowed almost all distinctions on the basis of sex, for example, prohibiting even a military school from accepting only men. Disallows distinctions on the basis of illegitimacy, one result of which has been to reduce the stigma that once attached to out-of-wedlock births. To whatever contribution it's made to it, certainly the most serious problem, racial problem, is that more than 2/3 of black births today are out of wedlock. Probably nothing worse can happen to a newborn than to be in that situation. The court has created and imposed on the states and the federal government a unique system of criminal procedure with Miranda warnings, exclusionary rules, known to no other system, in which the guilt or innocence of the accused seems often the least important issue. It's prohibited the states from providing for prayer or Bible reading in public schools, while also prohibiting most forms of state aid to religious schools and public displays of religious symbols. Prohibited the states from imposing congressional term limits. The list is endless. Perhaps the most remarkable demonstration of the court's unchallengeable power is its orders that public school children be excluded from their neighborhood schools and transported to more distant schools because of their race, in a futile attempt to increase school racial integration. It has permitted district judges to order the raising of taxes to obtain funds, over $2 billion in Kansas City alone, bankrupting the rest of the Missouri school systems, to comply with district judge orders, the result of which has been devastating to public school systems across the country and cities, driving the middle class out of the public schools and the cities, and doing absolutely nothing to improve education, or indeed improve integration, with a great list. Yet these orders continue to be enforced. What, one must wonder, seems to me has raised the question, would the cost have to be for an order not to be obeyed? 10 billion, 100 billion? Is there some point? Is there any point at which today's Americans are willing to say no to judicial tyranny? The court has done all this in the name of the Constitution. The issue of how the court should interpret the Constitution would seem, therefore, to be of crucial importance. Fortunately, it's not also a difficult issue. The court should interpret the Constitution to mean what it was intended to mean by those who made it authoritative, the framers and ratifiers, because that's what interpretation means, what it is. It's not a variety of methods of interpreting a writing. There's only one to attempt to determine the intent of the author, which is to say nothing more than there's a difference between reading and writing. Writing, you're seeking to communicate in words. In reading, you're seeking to get the communication of another. Two objections are made to this, however. The first is that we may not know the meaning intended or understood by the framers and ratifiers, the original intent. Or they may not have had any intent as to a contemporary question of policy choice, which is all certainly true, but does not authorize judges to make up new constitutional meaning according to their own policy preferences. The problem is easily solved. If we do not know that the Constitution prohibits a particular policy choice, when the court rules something unconstitutional, it's saying the Constitution prohibits this choice. If we do not know that it prohibits a policy choice, the only proper conclusion is that it's not prohibited. That's not difficult. Not that the justices can choose to prohibit it anyway on some non-constitutional basis. The second objection to insisting on original intent is that it means that we are ruled by the dead hand of the past, by policy decisions made by people who are long gone. And that is also true. But it is an objection to constitutionalism, to having constitutional limitations on policy choices. This is not a reason, again, to allow policy making by judges. Constitutionalism raises the question of rule by the dead. Judicial activism raises the very different question of rule by judges who are all too much alive. the real issue in contemporary constitutional law is not how judges should interpret the Constitution, but whether they should be limited to interpreting it, in fact as well as theory. That is, the issue is whether they should invalidate laws only on the basis of the Constitution, rather than on the basis of so-called natural law, moral philosophy, or some other non-constitutional ground, all of which amount, as a practical matter, to nothing more than the judge's personal political preferences. I define judicial activism very simply and clearly. There's a lot of debate. What is activism? So I have a very clear definition. It is judges holding things unconstitutional that are not. Isn't that easy? Disallowing policy choices the Constitution does not clearly forbid. I say clearly because if self-government is the norm, as it in theory is here, the judgment of elected representatives should prevail in cases of doubt. To refuse to hold something unconstitutional is not activism. It's inactivism, self-restraint, and to be commended. To overturn a prior activist decision is to disregard so-called stare decisis is not activism, as liberals claim. It's anti-activism, the undoing of activism. The much debated question of how judges should interpret the Constitution is actually irrelevant because no question of interpretation is in fact involved in almost any of the Supreme Court's controversial so-called constitutional decisions, because nothing is being interpreted. In sum, the first and most important thing to understand about constitutional law is that it has almost nothing to do with the Constitution. If you find that shocking or exaggeration, it's very easy to show that's literally true. The Constitution is short, apparently simple document, not at all like the Bible, the Talmud, or even the tax code. Further, short as it is, very little of it is even purportedly involved in the making of constitutional law. The vast majority of constitutional cases involve state, not federal law, and nearly all of those cases, surely over 95%, purport to be based on a single constitutional provision. As you know, one sentence of the 14th Amendment, indeed the 4 words, due process and equal protection, does not require jurisprudential sophistication to understand Supreme Court justices do not make decisions on a vast array of complex, controversial issues of social policy by studying those words. The 14th Amendment was adopted for a very specific and limited purpose, to grant certain basic civil rights to blacks. The essence of our problem of rule by judges in this country is that the judges have made those 4 words, due process, equal protection, into empty vessels into which they can pour any meaning, or blank checks they can fill in any amount. They've essentially converted them from meaningful legal requirements, with a knowable content ones, into a simple transference of policy-making power, authorizing the judges to remove from the political process and assign to themselves for decision the final say on any issue they choose. That's the essence of where we are. In Roe v. Wade, 1973, for example, the court held due process clause of the 14th Amendment precludes the states from the practice of abortion. Now, the 14th Amendment was 105 years old. All 50 states had laws restricting abortion. Isn't it odd that no one noticed until then that abortion is a constitutional right? How silly can you get? What do you suppose Blackmun was interpreting? The word due or the word process? The court's so-called constitutional decisions are not only typically without basis in the Constitution, but often in defiance of the Constitution. For example, the purpose of the religion clauses of the First Amendment was to guarantee that the national government would not interfere with the states in matters of religion. And yet, the Supreme Court, an arm of the national government, cites these clauses, relies on these clauses to prohibit prayer in the public schools, aid to religious schools, public display of religious symbols. Another example, the fact that the Constitution explicitly provides for capital punishment in several places doesn't dissuade Justices Brennan, Marshall, and Blackmun from insisting it's unconstitutional. Right? Can there be the slightest doubt that I don't exaggerate that the Constitution has nothing to do with this? I mean, if you'd come to understand that, it would be a huge advance. The second and final thing you need to know to fully understand contemporary constitutional law, in addition to the irrelevance of the Constitution, is that the court's controversial decisions in the last 5 decades have not been random in their political impact. On the contrary, their effect on nearly every issue has been to enact the policy preferences of the far left of the American political spectrum, the preferences of the American Civil Liberties Union and liberal academia. It is only a slight exaggeration to say the ACLU never loses in the Supreme Court, even though it does not always win. It either obtains from the court a policy decision it can obtain in no other way, because opposed by a majority of the American people, for example, a prohibition of prayer in the schools or removal of restrictions on pornography, or it is left to try again on another day. It took 3 shots, for example, to have the Connecticut anti-contraception law finally invalidated on the 3rd try in Griswold v. Connecticut, right? Connecticut was simply not big enough for that law, and Yale. For conservatives or traditionalists, however, the situation is precisely reversed. For them, a so-called victory in the Supreme Court is typically not the court's enactment of a conservative policy preference, but simply the courts permitting conservatives to continue to fight for their position in the political process. But we hear much talk today about a conservative court as a result of the Reagan and Bush appointments. In the popular media, however, a conservative court is not one that enacts conservative policy preferences, but only one that enacts liberal policies less reliably. A court that took away a past liberal victory, for example, overruling Miranda, exclusionary rule, Roe v. Wade, prayer in the schools, none of which has been done, of course, would be not merely conservative but reactionary. A court that regularly gave conservatives positive victories on policy issues equivalent to those it gave to liberals, for example, by holding that the states must prohibit abortion or must provide for prayer in the schools. This, of course, would be not merely reactionary but unimaginable. Instead of overruling Roe v. Wade, as was expected, the Rehnquist Court not only reaffirmed it, but extended it by invalidating restrictions even on so-called partial birth abortion. It not only reaffirmed the prohibition of prayer in the public schools, but extended it to a student-composed, non-sectarian reference to the deity at a high school football game. Instead of cutting back on the near-absolute prohibition of sex discrimination, the court extended to even an all-male military school. Colorado may not deny special rights to homosexuals, it held. Congress may not protect children from obscenity on the internet. And the states may not enact term limits. All of these are the policy choice favored by the ACLU. If this is a conservative court, what more, you might ask, could a liberal court do? The only reason a court delivering such a string of liberal victories can be considered conservative is that liberal victories are seen as the norm, simply the court performing its usual function. While a conservative victory would be seen as an aberration, a deviation from the natural order. There is such a thing, however, as conservative judicial activism, or judicial activism of the right. Although conservatives, almost by definition, are much less in need of activism. There's less about our society traditions they're trying to change. Less in need than liberals. And the Rehnquist Court did try to give conservatives positive victories, primarily in 3 areas, in 3 issues: race preferences, regulatory takings, and federalism. But these efforts have failed as to the first 2, race preferences and regulatory takings, and will amount to nothing as to the third. The explanation for this, continuing liberal victories, no significant conservative victories, is that the so-called conservative court was actually made up of 4 highly reliable liberal activists, acting almost as a single unit, and only 3 not quite as reliable conservatives. The conservatives needed both swing votes, O'Connor and Kennedy, to prevail, while the liberals needed only 1. And when it really counted, as on abortion, 1 or 2 was usually available. The vast majority of constitutional law professors in law schools, political science departments, like the vast majority of all academics, media people, and other members of the cultural elite, share the Supreme Court's liberal policy preferences. The greatest fear of the American intellectual is that policy making should fall into the hands of the American people. The American people, after all, favor capital punishment, prayer in the schools, restriction of pornography, neighborhood schools, strict enforcement of the criminal law. Who could live in a country like that? Not my colleagues. The basic defect of democracy, as these intellectuals see it, is that people with such backward views get to vote. The function of constitutional law, in their view, is to correct this defect. And the function of constitutional law professors is to justify constitutional law to the American people. Keep pretending it somehow has something to do with the Constitution as a start. Plato favored government by philosopher kings. But who could favor government by lawyer kings? If it's philosopher kings we want, shouldn't we at least get philosophers? If it's moral guidance we need, would anyone's mind turn first to lawyers? It is not politically possible in this country to argue that giving the final word on controversial issues of basic social policy to majority vote of 9 electorally unaccountable lawyers, it's by majority vote, all right, but of those 9, that this is an improvement on the democratic federalist constitutional system, that can't be argued. Yet incredibly enough, this is the system we have. Precisely describes it. Proponents of this system must there construct ever more imaginative theories of constitutional interpretation, the aim of which is not to discover alternative methods. There are none other methods of interpretation, but only to conceal the fact that the only issue is who should govern. They and the cultural elite, the court is the effective mouthpiece of academia, of liberal academia, or the people. Democracy, Churchill famously said, is the worst form of government except for all the others that have been tried. The experience of the last 50 years demonstrates with increasing clarity that government by judges is not an improvement on government by the people. Whatever may be the best form of government, surely policy making by majority vote of 9 unelected, life-tenured lawyers pretending to be interpreting the Constitution has to be the worst. Thank you. Leave me your pencil. I seem to have left mine.
Okay. I may need it back while I'm talking, but Good afternoon. Patrick, thank you and the Federalists very much for sponsoring this debate. I think it's a very important subject, and I personally appreciate the opportunity to participate in it. If I might begin by talking about my view of the constitutional world and the world in general, it's that not all wisdom is on one side of the question. Sometimes conservatives are right. Sometimes liberals are right. Sometimes moderates are right. I think it's important that we listen to all sides before we determine which is right on a particular question. And so, for example, in at least one particular, I agree with Professor Graglia. I do think that Roe v. Wade, at least ab initio, was wrongly decided. I don't think at this late date, after the question's been before the court as to whether it should be overruled, that we should overrule it now. I don't think we should make it like, as the first Justice Roberts said, a restricted railroad ticket good for this day and this day only. But I, despite being ardently pro-choice philosophically, argued before Roe v. Wade that the Fourth Circuit Federal Court of Appeals should uphold the North Carolina limitations on abortion, not because I believe them, but because I do think that judges shouldn't make up constitutional rights, and I did think in that instance they were doing it, even though it was one I would have liked. Now, conservatives, I don't think are necessarily or always following that same philosophy. Professor Graglia tells us there's no real conservative activism. I would suggest that's not the way it's worked out. In fact, the one almost perfect conservative counterweight to Roe v. Wade is Bush v. Gore, where quite frankly, I think judges were even more so than in Roe concerned with the particular issue, and what's worse, concerned with particular personalities, and consequently stretched equal protection far beyond recognition in order to reach a politically palatable result that they wanted. They had the nerve to say that equal protection was violated because the recount might not be perfect, as if an imperfect recount wouldn't be better than no recount at all, Well, it might not be if you don't like the particular result. And the shame of it all is if they hadn't made that outrageous decision, Bush probably would have won anyway. Another illustration of conservative activism is that where the appropriate political powers have determined that racial affirmative action is a good thing, and indeed we're told that the very purpose of the Equal Protection Clause was to protect African Americans, an activist court is perfectly willing to step in and say, no, this policy choice cannot be implemented, that instead we will decide for you when you can apply affirmative action and when you can't, and most of the time, actually, you can't. And so it does go both ways. Now, I don't believe that the court should utterly stay out of this. Let me talk to you generally about how I think constitutions ought to be construed. First of all, we did not, and the framers never intended, for a Simon pure democracy. It would certainly be plausible to set up a government where the people's representatives could do anything they wanted. Instead of doing that, we set up a government whereby the people developed a constitution which was, as one justice said, is full of thou shalt nots as to what the government can do. Basically, the people recognize that all of us are sometimes minorities, and that there are some things that the majority ought not to be allowed to do. The trick is figuring out what they are. Justice Jackson once said that the very purpose of the Bill of Rights was to withdraw certain controversies from the vicissitudes of public opinion. And again, the question is, well, what are they? I would tend to go more with former Chief Justice Marshall in McCulloch versus Maryland. Marshall, of course, who was much closer to the framers than even old war horses like Professor Graglia and I were, took the position that the Constitution should never take on the prolixity of a legal code. Something that I think Professor Graglia would probably like the Constitution to do. As Marshall put it, it was enough for the framers to understand that they created an organism, that there would be room for others to put flesh on it. And he emphasized in considering this question, we must never forget that it's a constitution we are expounding, that all we can do, all we can expect to do is lay out the great outlines. And it's for others to take our general work and to put specific flesh on it. Justice Black said a strict construction of our basic rights deprives them of half of their efficacy. I think he was right about that. Now, we do need to know what our basic rights are. Certainly one of them, maybe the core, is freedom of speech. It doesn't say freedom of speech except for something that somebody calls obscenity. Yet Professor Graglia is upset that even some sexually explicit material is protected. He should be upset with the opposite problem, that all of it isn't protected in spite of the fact that the Constitution says that freedom of speech is protected, not freedom of speech except those that 5 justices happen to think qualify as something called obscenity. So I think the problem there is in the opposite direction. And let's look what happens when the court does try to get a little bit too restrictive in terms of the way it construes the Constitution. Let's talk about a couple of cases from last term. One, Gonzalez v. Raich. This was a case, some of you may know, in which a federal statute precluded the distribution of marijuana, even for the purpose of protecting a very, very sick woman from getting the kind of medical use of the marijuana that she needed. California had made a different policy choice. Now, Professor Graglia in his opening remarks talked about how important it was that we allow most decisions to be left to the state. Only a few were delegated to the federal government. I wouldn't think deciding whether a very sick woman can use marijuana that she gets for free that had never left the borders of the state of California would qualify, but the Supreme Court did. The Supreme Court taking the position that we don't much care about Justice Brandeis's little laboratories. We don't much care about giving states the opportunity to experiment. No, we will go towards giving federal power. We will allow Congress, the all-knowing national legislature, to decide what's good for California and Texas and North Carolina and every place else. Instead of letting California do one thing, North Carolina do something else, and the rest of the states study what these two have done and decide for themselves, which is the better policy. This comes from taking this very parsimonious or restrictive view of the power of the court. And in another case last term, Kelo versus New London, the Supreme Court took the position that the Constitution does say that there shall be just compensation when private property is taken for public use, that we won't read this as any kind of significant limitation as to when private property can be taken. And as a result, I think all of us who own property are a little bit less secure. Actually, it doesn't affect me too much. My particular house is on a cul-de-sac, and my very wealthy next-door neighbor bought up the lots surrounding it, and I think it's highly unlikely that anybody's ever going to take it for what they consider a public use or a public purpose. But some of us that live on larger streets maybe aren't so fortunate. And I think that was kind of an unfortunate decision, but I think it is the direct product of construing constitutions the way Professor Graglia thinks constitutions must be construed. He didn't say so, but I got the distinct impression that he takes the position that the Due Process Clause should not be held to incorporate the Bill of Rights. Consequently, if I'm reading him correctly, and I'm sure he'll tell me if I'm not, that the first 8 amendments are applicable to the federal government and the federal government only. Think about what it would be like for a moment to live in a world like this. He worries about Iran and the Ayatollah. Imagine a world where if the government feels like it, they can bust into your house anytime they darn well feel like it. Any evidence of crime they find is going to be admissible, therefore there'd be no reason for them not to do it if they think they're going to find evidence. If you live in a town like, say, I do, Chapel Hill, which is heavily controlled by Democrats, maybe they could pass a law making it unlawful to say anything favorable to the Republican Party. Well, that's what the people's representatives have done. Hey, there's nothing in the words due process. It doesn't fit due and it doesn't fit process. So maybe that's perfectly constitutional. Maybe it's perfectly okay to do that. He wanted to do away with Miranda. He wanted to do away with MAP. I suspect he'd want to do away with the whole Bill of Rights because it doesn't specifically say that they're applicable to the applicable to the states. Let me focus on one of the cases that Professor Graglia alluded to some in his litany of expansive decisions, one that I happen to think was rightly decided, and I want to tell you why. That's Lawrence v. Texas, the case holding that it was constitutionally impermissible to consider morality as a justifiable reason for legislation. To my mind, that had always been the law until the court jumped the tracks in Bowers v. Hardwick, saying that morality alone can be sufficient to justify legislation. And why do I think that? Well, recall the Griswold case, the case that Professor Graglia was so concerned about with Connecticut's law forbidding the use forbidding married people from using contraceptive devices. Of course, that was an uncommonly silly law, and everybody knew that. Certainly, one of the things Connecticut could have done, if morality was enough of a justification, would have been to just to say, well, our legislature thinks it's immoral to use contraceptives. End of case. I mean, how can you argue that? Somebody says it's immoral, then in their opinion, it's immoral. You don't have an argument. Why is it immoral? Well, God said it was immoral, the way I listened to God. Is that going to be enough? Well, that should scare you a little bit into thinking maybe there's some Establishment Clause problems here. That maybe Connecticut figured out if it had argued that it was immoral, it would lose, because morality without some kind of other secular justification isn't going to justify a law. And so they made this kind of ridiculous argument that said, well, if married people were allowed to use contraceptive devices, they'd be more likely to have contraceptive devices. And if they had contraceptive devices, they would be more tempted to engage in extramarital activity. And the state has a legitimate interest in preventing adultery, therefore married people can't use contraceptive devices. Well, Justice White kind of understated that the intrinsic validity of this argument is not readily apparent. But Connecticut was reduced to making that argument because they were passing a law based on morality alone, and they knew that wasn't a sufficient justification for the law. So they had to try to make something up, and that was basically what they made up. Lawrence is of the same mode. Now, if you take the position that morality is sufficient, suppose a particular legislature decides that it would be immoral not to go to your nearest Baptist church every Sunday from 11 a.m. to 12 p.m. What'd be wrong with that? Say, well, gee, it establishes a religion. Well, maybe it does. But if the only thing you can say is wrong with homosexual behavior is that it's immoral, why is it immoral? Well, just look in your Bible and you'll see why it's immoral. Then I think you do run into that kind of a problem. Now, whatever might be said for Roe v. Wade, I don't think that's in the same category, because there you're protecting something tangible. You're protecting a fetus. I'm not for the moment taking a position on the correctness of Roe v. Wade, but I don't think you could analyze that case on the same basis that you could analyze Lawrence. I don't think you can tar them all with the same brush. And one of the objections I have to Professor Graglia's theory is that I think he does tend to tar them with the same brush. A couple of other things. His comment about capital punishment. That we had capital punishment at the time the Constitution was adopted, therefore how could it possibly be unconstitutional? I think there's an answer to that. There's the difference between a general provision and a specific provision. It is certainly possible to have a general provision, there shall be no cruel and unusual punishments, and yet not specifically ask yourself the question, is one of the punishments that we're currently enacting cruel and unusual? It is at least plausible that one could say that if they'd thought about that question, they would have realized the conflict. But it may be that later evidence indicates that the manner in which the death penalty is carried out, the slow walking down the pathway to your death, is very similar to the kinds of things they didn't allow. And so the fact that the framers might not have specifically seen the conflict doesn't necessarily mean that their words won't support it. And for general support on this concept, I'd recommend reading an article by your own Professor Jefferson Powell called The Original Understanding of Original Intent, in which he indicates that the framers didn't mean their very specific ideas to be chiseled into stone when they wrote the Constitution. I'll close with this thought. It strikes me that Professor Graglia's theory would essentially like to replace constitutional lawyers with computers. That is, if only you had a computer, if only you could plug in the right things, you'd know all of constitutional law. That he'd probably replace con law teachers with computer programmers, then I guess we would have to retire, wouldn't we, you know, if that ever happened. Finally, I think that he simply doesn't leave room for judgment. Like, this is all set out, this is all simple, that's all there is to it. All you have to do is, again, as the first Justice Roberts said, take the Constitution out, read it. Take the statute out on the other hand and look to see whether the former squares with the latter. There's no judgment involved. Well, in the constitutional democracy I like to live in, there certainly is judgment involved, and frankly, I'd like to see it stay that way.
The most important thing probably in these gatherings is a astute audience comment. And I violate that to the extent I speak. If you're all, I try not to be provocative so as to bring out comment, but it usually does. And I think if any learning takes place, it usually does. But let me quickly say a few things. My theory talks about what is my theory? My theory is if it's not clearly unconstitutional, it isn't. Is that a difficult theory? Right? And if you can't say, yes, this policy choice is prohibited, then it's not. Now, what is he telling us? Is, my God, that would leave us in the hands of the legislatures. You know, it's all this one essential thing. The only thing that is saving us from our fellow citizens are these wonderful lawyers on the court. You know what they could do? They could say we all have to go to the Baptist church. Wouldn't that be terrible? They're not about to do that. The Supreme Court's saving us from that. They're not saving us from that. They're saving us from having 10 commandments on the courthouse wall. That's all they're saving us from. You know, these American legislators are Americans. They live in this country. They share our mores. You could even incorporate the Bill of Rights. It really wouldn't make any difference. Right? Then you say no double jeopardy requirement would apply to the states too. Well, no state has a double jeopardy requirement. It wouldn't matter. You know, freedom of speech, this is a beautiful example. If you really, sophistication, understanding. You know, the Constitution doesn't say freedom of speech except for obscenity. Damn it, it says freedom of speech. Right? And that settles that. It says Congress shall not, notice the first word is Congress. Congress shall not pass any law abridging the freedom of speech. Well, first of all, that can't mean what it says. It is not possible that a government is not able to control and prohibit speech. No doubt about that. Well, then what does it mean? And what does it tell us? And the answer is nothing. Supposing Congress passes a law that says, you know, if you say to me, I'll raise my price $10 next week, and you say, I'll do it too, you've committed a crime. Wait a minute, where's freedom of speech? You know, it doesn't say except for obscenity. It doesn't say except for price-fixing agreements. It doesn't say anything. When the court holds a price-fixing agreement merely exchange of speech is perfectly constitutional, why is that? Because they consider it reasonable. And because the First Amendment has nothing to do with it. Sheds no light on it. Right? Question, should there be nude dancing? Should there be flag burning? I mean, should you be allowed to interrupt when someone is speaking? Well, of course you can be taken out for interrupting. Of course you can be taken out for a conspiracy to commit a crime. An endless number, and perjury, endless numbers and types of speech can be prohibited because they consider reasonable. And the First Amendment isn't doing any of this. All right, quickly, you know, Bush v. Gore was, no doubt, was activism. He's right about that. If anything justifies activism, and in my view, very little does, it's overcoming activism. The Florida court was trying to give the election to Gore. The Supreme Court decided to give it to Bush. I already said affirmative action was activist, and that was considered the most important thing that the conservatives were winning. We're getting affirmative race preferences knocked out. And that was so important that some big liberal common law profs were beginning to wonder whether we needed judicial review if they were going to knock out race preferences. Well, of course, O'Connor gave every indication that they were going to knock it out, as you know, in a couple of cases. But along in the Grutter case, the Michigan case, it's over. You can use race preferences after all. So the liberals won. O'Connor switched to their side, as you might happen. And do I want a prolix constitution? I'd like to have a shorter constitution. I think constitutional restrictions are probably mistakes. Do you realize, for example, that we live in a country with an unconstitutional vice president? You probably don't know that, do you? But you do. He's unconstitutional in my view. Why? Because the Constitution says that the electors of any state can't vote for both president and vice president to inhabitants of the same state. Now, George W. Bush was the governor of Texas, so probably clearly an inhabitant thereof, right? Now, the question is, where was Cheney an inhabitant? Well, he lived in Dallas, he worked in Dallas, he voted in Dallas, he drove in Dallas. Looked like an inhabitant of Dallas to me. Unconstitutional. Who needs it, right? I mean, wasn't that wonderful? The Constitution does that for us. It went to court. You know, it was sued on this ground, and some district judge says, hey, who gives a damn? You know, which is sensible. The Constitution's a pain in the tail. It's giving problems we don't need. Let's today's world and today's people make our decisions. And we don't need this group of lawyers to protect us from one another. You know, a Schwarzenegger can't be president. Perhaps more to your liking, Jennifer Glenville, very attractive in all ways, potent governor of Michigan, can't be president. Oh, you know, who needs that? It's unconstitutional. Well, maybe I should, Kelo, you know, the New London, you know, I depart from, it's mostly conservatives, not only way out libs like Loewy, but even conservatives of Wall Street Journal are incensed about this. The Supreme Court held that New London can condemn that land, that private property, pay for it, they paid generously, in order to give it to a plant that was going to create 3,000 jobs and revive the economy of New London, Connecticut. Was that a wise thing to do, that policy? Well, I sure don't know, but it certainly sounds like an arguable one to me. Should the Supreme Court come along and say, you can't do that? We want to protect Loewy's home? You know, why isn't that, is that such a bad law? Why didn't they realize that in New London? Why don't you go to London and talk about it? Why didn't they realize it in Connecticut? It seemed to them, yes, some people's homes were condemned, and it says this is for a very public purpose, a very useful purpose, and that's what eminent domain is for. In my view, as I say, it is very rarely, if ever the case, that the decision is wrong when the Supreme Court refuses to interfere. They refused to interfere in Raich in the marijuana case. Well, was that a bad law? Well, it comes from Congress. If you don't like it, why don't you talk to Congress? Does the Constitution say Congress can't do that? The Constitution gives Congress the broadest powers. The broadest powers, and you know, and the power to regulate interstate commerce obviously has to include the power to regulate things that affect interstate commerce. Everything affects interstate commerce. So when is it affected enough? Well, who's to decide, the court or Congress? The fact of the matter is that people in this country want a normal national government with all power that can pass laws against kidnapping, laws against rape, laws against animal mistreatment, and they do. Congress has none of those powers. But to me, that's the I'm for a living constitution. A constitution that removes constitutional restrictions, not a Brennan constitution that multiplies them.
I could say a few things. I'll just say two things very quickly. First of all, as far as freedom of speech goes, the phrase is freedom of speech. It's not speech or it's not words. Obviously, when words are being used to commit a particular crime, such as perjury or kidnapping or robbery or something like that, it's not the interchange of ideas. It's the interchange of ideas that the concept of freedom of speech protects, and that clearly does take care of flag burning. I don't think that's a close question. As to whether the Constitution says Congress can't do it in regard to marijuana, I'd say, yeah, it does say that. We do have the Commerce Clause. We do know that some of Professor Graglia's favorite judges have been clear in Lopez and Morrison, saying that Congress can't regulate guns in schools and can't regulate violence against women. And that's not even conflicting with what the state's trying to do. No state that I know of is in favor of kids having guns in schools or in favor of violence against women. It's just a question of whether the federal government can supplement, and the court said no. But when it comes in direct conflict with the state, as it did in the Raich case, then the court's willing to let it go. Certainly an inconsistency and an unfortunate one. And while undoubtedly I could say more, I choose not to and prefer to open the floor for questions.
Let me just say, I think he's right about that. There is an inconsistency. I wrote an article opposing the Lopez case. I think that, again, in my view, when the court holds something unconstitutional, that's activism. And this is not clearly unconstitutional. So I oppose the Lopez. You know, he says, we've got to really understand the First Amendment is, well, it's an exchange of ideas. That's why pornography is protected, right? I mean, pornography is a masturbatory aid. Where's the exchange of ideas, right?
It certainly is advocating a particular licentious lifestyle, which other people would advocate against. And it's doing it, and it's appealing to the emotive process, which the court in the Cohen case said is protected, as well as a cognitive appeal. But I don't think we really want to get into debating just First Amendment theory.
When you tell me
let's take questions.
When you tell me what the court said in some case, I find that really impressive. Okay, questions?
Mr. Graglia in particular, I don't really want to try and engage the idea that you're wrong on the merits, because I think it's a very large project. I want to instead point to something I see as a deep inconsistency in what you're talking about, though, which is it's typified by the fact that you laud the federalism decisions in general of the Rehnquist Court. But I see it as...
I'm sorry, I don't. Insofar as they hold them unconstitutional, and that's where they're getting the most flack, is that, you know, Lopez and Morrison, they're holding these laws unconstitutional. I oppose those. I wrote an article opposing those.
Sure. Specifically, I'm thinking about the state sovereign immunity cases, which I would guess from your comments that you generally support.
No, I don't.
You do not. So you would fall more on the Hibbs line than say with Kymel in terms
the question
of
is,
congressional authority.
does the Constitution clearly disallow the policy choice that Congress makes in those cases? And it seems to me there's no way you can say it does.
So why isn't there an inordinate concern among conservative activists who care about strict textualism to go back and revisit Hans versus Louisiana? I mean, what is it about the 11th Amendment? And I can pick and choose other particular constitutional provisions. And the most important one, the thing that I really think is the deep inconsistency, is when you talk about whether or not something fits into the word due or the word process, when it could very easily fit into the word privilege or immunity, why it is that we ignore certain provisions in the Constitution under a conservative view, but other ones we insist that they be strictly construed according to the words on the page.
Well, if what you're saying is that conservative arguers can be inconsistent in some ways sometimes.
This is my point about not attacking you as being wrong in the merits.
Well, if we had time, you can attack me on the merits too. That would be very interesting. But you're right. There's inconsistencies. I say you'll see people. You see, certainly the Wall Street Journal publishes an article by me about the Supreme Court shouldn't be making these decisions, and the next day they publish an editorial denouncing the court for the Kelo decision, that the court should have stepped in and held it unconstitutional, which is exactly the opposite of. They love it when I tell them this until they see a decision they like. So inconsistency is not exclusively with liberals. You're right. We want or don't want or strict construction of some things and less of other things. I don't think so. You can talk about your privileges and immunities clause of the 14th Amendment. The question still becomes, should the 14th Amendment, and the privileges and immunities clause might seem linguistically more apt than due process. You're right. The question still becomes, should the 14th Amendment be understood as, in essence, allowing the court to disallow any policy choice they disagree with? That's what we've come to. And there's no reason to think that. You know, Loewy tells us this is not a pure democracy. Bicameralism is not pure democracy and so on. But also, the framers seem very clear that one thing that clearly would not happen and shouldn't happen is judges would make policy decisions. You know, Hamilton was the theorist of this, but it would only be, they disallowed things that were clearly inconsistent. Marshall says, let me give you an example. The Constitution says you need two witnesses for the crime of treason. What if you had a federal statute that said one witness? That would be unconstitutional. You bet it would be, and I would hold it. But Congress has never passed that law. Why not? They can read, right? So it is not the case that I'm saying it is not the system of the Constitution that the court gets to make the basic social policy decisions. Where we are now, that's what happens. The Constitution has nothing to do with it. How many times can I prove that to you? There was a time when the Constitution permitted the assignment of kids to school by race. There was a time when it prohibited the assignment of kids to school by race. There was a time when it required the assignment of kids to school by race. And the Constitution never changed. Does that show you something? Obviously, it has nothing to do with it. It's not the operative variable. So if you're accusing me of inconsistency, I've probably been praised by opponents as being one of the most consistent. I mean, I did not say they should hold affirmative action unconstitutional. I think affirmative action, race preference is a social disaster in every way. I give long speeches on that. But if the people of California want to do that, it's their country. I do not know of a way to improve on the judgment of the majority of our citizens. I do think, I agree with George Orwell that there are some ideas so preposterous that only the highly educated can entertain them. And that seems to me to be very much the case. This is essentially government by the Harvard law professoriate. And I agree with Bill Buckley's famous statement that he'd rather be governed by the first 2,000 names in the Boston phone book than by the Harvard faculty. And we are being ruled by the Harvard faculty. The Bakke case, Powell was perfectly snowed. He says, hey, look what Harvard has done. They found a way to racially discriminate without racially discriminating. Isn't that wonderful? That's what they say. And I, just being a stupid lawyer, I believe that. So that, you know, if you want to get to attacking the merits, we can do that. But maybe there's another question. Go ahead. Yes.
I understand. I think I understand better now in response to the question of your argument. But it seems like there's a fundamental difference, even if you believe at all in the principle of judicial review. There's a fundamental difference between looking at the Constitution and saying, well, if we require 2 witnesses for treason, and this statute requires only 1, there you've got a contradiction, and it's unconstitutional. And then you have something saying that protecting us against deprivation of due process or equal protection, you can't use that same mechanical analysis to go and look and say, well, is it prohibited or isn't it? There has to be, you have to give some meaning to those terms. And so then immediately you're then into the debate about what those terms should mean. And you can disagree with someone about what the content of due process is, but you can't go through that sort of a mechanical process of just checking and saying, well, we have nothing to say unless it's clearly prohibited, because nothing is clearly prohibited.
Okay.
Until you give a meaning to those words.
If we're going to have something other than rule by judges, the judges are supposedly applying law. And they're not applying law unless, in fact, there is law. That is meaningful, predetermined, authoritative. It's meaningful. And therefore, insofar as they're going to apply the 14th Amendment as law, it should be something that has a meaning. And with its history and why we have it, its meaning is very clear. There was the 1866 Civil Rights Act, as you know, that gave the blacks basic civil rights, right to contract, own property, and so on. President Johnson vetoed it. He said it's unconstitutional. Congress doesn't have the power to do it. And so they passed the 14th Amendment in order to constitutionalize that act. That is, not only make it clear that Congress had the power to do it, but also to make it part of the Constitution. So the purpose of it is fairly clear. I mean, it's very clear. And there's going to be, you can argue about different things. Surely it applies to discrimination against Chinese as well as blacks and so on. But this was the idea, was to give basic civil rights to blacks. And as I think Miller very properly says in the Slaughterhouse Case, is except for that, none of this would have even been suggested. Try to understand what's happening. We had a civil war of the issue of slavery. The states then passed these black codes to hold blacks, deprive them of basic civil rights, and the radical Republicans in charge of Congress did something. That's why we got the 14th Amendment. Did we go from that? He said, is this to make us the perpetual censor of all laws? We've got a provision here to give blacks rights, and we got a case in which white butchers are protesting New Orleans' control of slaughterhouses. How did that happen? He says, are we the perpetual censor? Whether or not Louisiana or New Orleans can control slaughterhouses now is for us to decide because we have the 14th Amendment? He says that can't be right. And I think he's correct. It's very easy to say, what does without due process mean? That means you should be grabbing people and throwing them in jail. You got to treat them according to whatever the legal process is. That's very clear. This isn't mysterious. Oh boy, the generalities, the vagueness. You know, what this meant was very clear. The problem with what it means, and it's very clear, is it doesn't mean enough. Loewy just quoted to you, my goodness, if you use these phrases to mean what they're supposed to mean, we wouldn't have practically any protection. And boy, do we need protection. Boy, do we need courts doing things. Otherwise, we're subject to one another. So there's no great mysteries there. If you would all favor, in fact, the constitutional system of Republican federalized government, you want, far from there being a prolix constitution, I'd want a short constitution. I think constitutional limitations are very hard to justify. Very hard. I mean, is it a good idea that you have to be a native-born citizen so that we can't vote for Schwarzenegger or Glenholm? And so on. The constitutional restrictions are hard to justify, but that's not our problem. Because, and incorporation of the Bill of Rights is not our problem. Because if the judicial review was what it purported to be, disallowing policy choices that are in fact, one could realistically say, the choice has been made to disallow, you would have very few things held unconstitutional. I was in a debate once where...
I don't think that's the document that our framers passed. I don't think they meant to be that, to give the legislature very nearly carte blanche. I think there was an intentional effort not to do that. It would have been possible to write a document that simply said Congress can do whatever it feels like, end of document. It did not write that document, and there's a very good reason it didn't write that document.
Well, there's two things. There's the federalism question and there's the prohibitions. On the federalism question, the Constitution is really inconsistent in intention. That is, Madison and Hamilton, the two major figures, didn't want a totally centralized federal government. And so Madison arrives to the convention with a plan that would have done that. Congress can veto state laws and so on. Then they had the whole convention was a matter of somewhat limiting it to get the damn thing passed. And they got it passed, and now the question is, what Congress has enumerated powers, but they're so broadly stated. You know, Patrick Henry and so on that would say, wait a minute, they've got to be defined. We need a 10th Amendment. Congress only has the power that is expressly granted. And Madison, clever devil he is, he says, I'll give them their amendment and shut them up. And so he passes an amendment, Congress has only the powers granted. He leaves out expressly. It gets to McCulloch v. Maryland and Marshall, the other great nationalist, buddy, mentor of Hamilton. He says they left out expressly. You know what that means? That means Congress can do whatever it wants. So the 10th Amendment, it turns out, has exactly the opposite effect. Right? You remember that in McCulloch? So the limited power of Congress.
Don't forget the Amendment 1 through 9 that it added too. It wasn't just the 10th Amendment.
Well, then Then the other amendments were added. Again, basically of a federalism nature. So it meant to keep First Amendment, keep Congress out of doing anything with religion. Congress cannot abridge the freedom of speech. Well, that can't mean what it says. What does it mean? Well, the idea was apparently, or referring to Blackstone, what that meant was no prior restraints. Congress can't license the press, right? If I was once, Nina Totenberg was a judge in a debate I was having with Mark Tushnet, and she says, according to you, Professor Graglia, nothing's unconstitutional. I felt like saying that's not really my position. My position is nothing's unconstitutional that happens. And she says to me, could you give me an example of a state law you would hold unconstitutional if you were on the Supreme Court, right? I could hear her mumble under her breath, God forbid. And I said, sure, no problem. I said, if a state passed a law saying women can't vote, I said, now I don't want to pass on the merits of that. I know she'd enjoy that. But it's unconstitutional. And she really acted like I had cheated. She said, but, no state would pass a law women can't vote. I said, of course not, they can read. That's why it doesn't happen, right? I mean, the idea here is, what the hell's the point of the Supreme Court and judicial review unless they can hold things unconstitutional that aren't? So they can push the views of some elite. At the turn of the 19th, 20th century, of course, they were conservative and they wanted to do in socialism. And so all of a sudden, every kind of socialist measure was prohibited. You couldn't take property without paying for it. Why? Because they were incorporating the Fifth Amendment? Nobody ever heard of that idea. You couldn't do that because it was against the laws of God and nature, for goodness sakes. Right? So that's what they were doing then. And now since coming the Warren Court Revolution and the strange things that have happened in academia, they went from this making constitutional law in the court a brake on innovation and social advance into the accelerator. Almost virtually all of a liberal nature. Vastly of a liberal nature. The Rehnquist Court, this affirmative action thing, that was a biggie. And it failed. The other biggie was regulatory takings, and with the Tahoe Sierra case, that has failed. And nothing's going to come of the federalism cases. Next question. Go ahead.
You had said early in your opening statements that there's only one way to engage in interpretation. And as your talk went on, you said that if we want to interpret morality, we go to the experts on morality, and so on. And I want to suggest that the experts on interpretation, those people who study professionally textual interpretation, would have a strong disagreement with you just look to whatever the author meant. And in point of fact, the dominant view among people who study textual interpretation is going to be that you can't ever get to what the author meant. And I want to suggest that poses some challenges to your view, and I'd like to hear your response.
Yes, it is a debated area. A very famous literature professor was here some years ago. Most of you I now see don't even remember him, but Stanley Fish was a top deconstructionist student of Derrida. And the words mean nothing. The author isn't doing anything. The reader has to supply the whole meaning. Radical stuff like that in deconstruction. And so that's thought that, I agree with that group, and it seems to me it is the case, that it is possible to communicate. It is possible to communicate, strangely enough, interestingly enough, with marks and noises. We make marks. It's really a remarkable thing. It's so remarkable, that people think it's magical. I can say, please get up and close the door. I make those noises and the door gets closed. Or go get my umbrella in the closet. It seems magic. I can do that or make these marks. Yes, and communication is possible. And when these words and marks have meaning, are possible items of communication, only because a human being is seeking to communicate. Otherwise, they do not. One of the wonderful discussions of this, what's his name? I forget the linguist, one of the leading people. He points out, suppose you came to a beach and you looked at the sand and you saw on the sand that seemed to say help. The twigs were there or the waves. And you say, oh my God, somebody's in danger. And they said, oh, wait a minute, the waves made that. You say, oh, it's meaningless. It's only, these marks have meaning only on the assumption someone's trying to communicate. You have to assume that there's a language, first of all, a certain alphabet, a certain language, and then it's a human being communicating. Otherwise, they're meaningless. And the process of looking at these marks is to get that communication. The only reason that's possible, of course, is because of convention. Because of convention, these sounds, in fact, have meaning. Law is largely possible because, or necessary, or lawyers, because those conventions run out. And we're always in the case in law on dealing with words where, they don't have the normal meaning. Is a fetus a person? Well, we know what a fetus is and why it's there and so on, but we're talking about the word. Because person is not ordinarily applied to the fetus. Is the Caspian Sea a sea or a lake? Who cares? It is what it is, right? Law cares because there are rules about seas and lakes. And whether that's called sea or lake makes a big difference.
No, I think I might add on that. In the flag burning case, which we've referred to, the Chief Justice Rehnquist came up with this remarkable comment that he said, this isn't protected because he isn't really saying anything. It's like an inarticulate grunt or a roar. And if those of you who have read his dissenting opinion would know, understand this response, he said, boy, you're sure getting upset over something that doesn't convey anything or that doesn't mean anything.
So my answer to you is I insist that, in fact, communication through marks and noises in the form of words is possible, and that it depends entirely on there being an intent in the user of these marks and noises, and that reading a document is an attempt to get that intent. And writing using these words and marks is an attempt to send that intent. So to the extent that Derrida or others disagree with that, I think that's wrong. I think this is ordinarily what interpretation means, was generally thought to mean the normal use of the word. And I don't think anything else makes sense. If it is not an attempt to get the author's intent, then what is it? Well, according to Derrida, the meaning comes entirely from the author. Well, then it seems like communication is not possible.
Again, I'd recommend reading your own Jefferson Powell's article in the Harvard Law Review, I believe 1985, on the original understanding of original intent, where he, if I read him correctly, strongly suggests that the framers didn't intend that their two specific thoughts be the hallmark of the construction of the document.
You know, it's not specific thoughts. It's not if we found out that Madison really meant a certain thing and he wrote it, that would matter. Obviously, it shouldn't. The only it became authoritative when it was ratified. What did the people think they were ratifying? That's the question. And again, I would go for the minimalist reading. We want to restrict popular government as little as possible. To have these constitutional restrictions on today's choice is a very questionable matter. I mean, maybe it can be justified, but it's difficult. Another question? Cleared up everything? Okay.
We've got one over there.
This will be the last question.
Thank you. I have a question. Well, it seems like you don't like the judgment law in general, which suggests that you would prefer to turn America into a civil law country, which may be fine, but I think that first of all, it would require a significant social and political change, and that suggests that your position basically is not conservative, because conservative, as you probably know, comes from the word conserve, and that refers to conserve the existing order of things. Having said that, I have two questions. First of all, do you have any kind of feasible plan into shifting more powers to the legislature? And if you do, have you considered the fact that, I mean, right now having an elitist court making decisions is not significantly worse than having a parliament make decisions, because as you know, with the current election system, you know, American parliament is the best parliament money can buy. And you know, in a situation like that, I would prefer actually to have 9 judges on a fixed salary make decisions about my life than the legislature that, you know, by the structure of the election process doesn't really address my interests. I was wondering whether you had any constructive, you know, ideas about the...
They have classes now?
Yeah.
This question is
This question is a little bit longer.
tending to be a long one.
In 15 minutes.
It says you're taking the Platonic position that it's better to have ruled by a philosopher king committee than by the people. That's certainly a possible position. Plato took it. It's not one you can openly espouse in this country, as I say. So just as a matter of argumentation, the people who oppose me never can say, you know, it would be better if the Supreme Court made the decisions.
Do you have any constructive idea of how to effect the social change you purport to?
All I want to do is have the Supreme Court have a more limited role, and the only constructive idea I have is to confirm Alito.
Okay.
We ain't going to do this any other way.
Let me add just a
Loi,
little bit.
30 seconds here, and then we'll wrap this up.
Thank you. I think the problem that we have with Professor Graglia's view is that sometimes the legislature, which is beholden to a temporary majority, where the temporary majority wants to do something which is inconsistent with the Constitution, they know that their job is dependent on the will of this temporary majority of the people. The Constitution itself intended to put the legislature beyond that, and the legislature can't be expected to be the guardian of itself. Judges who have life tenure, and this is a good thing, do not run that same conflict of interest. The judges, and I would not use the term Platonic guardians because I'm opposed to that concept, but the judges themselves, by having life tenure and not having to be responsive to the temporary majority, are free to do the job that they're set up to do, namely to ensure that the limitations on the legislature and the temporary majority are kept in force because the people in their higher moment put that into the original Constitution.
All right. Well, we'll end the debate formally with that. We'd like to give these distinguished and well entertaining professors a round of applause.
Good.